Hello and welcome to Legally Speaking with me, Tarun Mangia. Chief Justice of India, Justice Dhananjay Chandrachud, has sent out a very strong and significant message to the bar at large, requesting them that they should not seek adjournments unless they are really necessary. He also used the comment saying Tareek pe Tareek in Hindi, meaning adjournment after adjournment or date after date, literally. And also highlighted the fact that about 3688 adjournments, which is 3,688 adjournment slips, were circulated in the month of September and October. And there were also 178 adjournment slips on the day when Justice Chandrachud made this comment. Now, I have two very eminent lawyers practicing at the Supreme Court of India who is going to delve into this issue, explain to us what the Chief Justice of India meant, the ramifications of his comment, and what issues has the bar to rectify things. All of this and more in today's episode. Let me welcome Senior Advocate Arvind Nair, a well-known name at the Supreme Court, the NCLT, and other forums. Good to see you, sir, and looking forward to some interesting insights. I have with me Advocate Abhimanyu Bhandari, who practices at the Supreme Court of India, the Delhi High Court, in other firms, and a lot in financial crimes also. Good to see you, Mr. Bhandari, and looking forward to some interesting insights from you as usual. At the outset, may I request Senior Advocate Arvind Nair that in about 2 to 3 minutes, could you lay the ground for this show by sharing with us what the Chief Justice of India was trying to convey to the bar at large?
Look, Tarun, I think the Honorable Chief Justice of India didn't sort of leave this to interpretation. He was very, very direct. And I think what we know so far from the tenure of the Honorable Chief Justice of India, both as a Chief Justice and even before that, is that he's somebody who's proactive. He believes it seems he's always believed in taking the bull by the horns. So he's not somebody as a judge who will sit back and let something pass. He will take measures, or he will take action to tackle it. Now, there have been several initiatives which he's taken right from the time he took charge, but I'll come to those later. Let me just essentially first focus on this. Now, let me tell you that the Honorable Supreme Court today is the one court where circulating a letter sort of guarantees an adjournment. Every other court, whether it's the Delhi High Court or any other High Court or any other honorable tribunal or even the district court, trial court judges, if you want an adjournment, you have to go and request for an accommodation when your matter is called out for hearing, which then brings in judicial discretion into granting an adjournment. The Honorable Supreme Court, notwithstanding the fact that it's the highest court in the land, has this almost guaranteed system of accommodation, which in recent times perhaps has sometimes been misused and has perhaps now become sort of an albatross because of the sheer number of volumes that the Honorable Supreme Court faces. We've got these staggering numbers. I did know, we all have some, I'm sure Abhimanyu will agree with me. We all have some rough idea of how many cases are filed, how many requests for adjournments are made, but we didn't know that these exact numbers would be like this. It's actually unimaginably huge, these numbers. So now I think it's this number, and it speaks volumes about his sense of being proactive, that there was actually somebody collating this data. So these numbers are huge, and these numbers are disturbing because let's not forget that the first dictum or the first maxim, all of us, even out, whether in the profession or outside the profession, here is justice delayed is justice denied. We all know how many cases are filed, how much time it takes, how much pressure honorable judges are under, given the number of volumes they face. So I think it was that anguish and that background which brought about this comment. And it was a very direct comment. It's not skirted around the issue as is his style. I mean, he takes it up directly, whether it were IT initiatives, whether it were wellness initiatives. So he's sort of taken it up very directly that, look, this is the highest court in the land. And I think this probably applies to every court. Judicial time is valuable. You can't even put a premium to it as to how valuable judicial time is in a country like India with the kind of volumes our Honorable Supreme Court faces. So I think it's very clear. He set the ball rolling, and I'm sure there will be some changes. You can't merely circulate a letter without stating reasons. I think most letters that are circulated don't even contain reasons. A letter is circulated, and honorable judges have usually always accommodated, saying that there is a letter in this matter or this item or this case, and we will adjourn it. I think that is going to change. Probably we'll all have to make out a case if somebody wants an accommodation. Let's say I'm not there on a particular day, or the advocate on record is not there. I mean, as counsels, we are replaceable. Our mandates are usually when we are engaged by lawyers to appear, so we are very well replaceable. But let's say an advocate on record or a counsel on record is not available for any pressing reason, then I think that description will have to be given, that reasoning will have to be given, and an adjournment may not be available for the asking by circulating this letter. That I think is going to happen.
Very interesting insight you provided, that the adjournment for the asking may not be provided. And I think the message is being sent across to the bar. And of course, as you shared, the sheer numbers show that many times people blame courts for delays. But when lawyers themselves seek adjournments, that side has not been highlighted enough, which I think the Chief Justice of India rightly did. I'll go to Advocate Abhimanyu Bhandari. You spend a lot of time in the Supreme Court, arguing in court number 1 and other courts. What has been your experience, and what do you think the Chief Justice was trying to say, and what point is he trying to drive home, especially among the younger set of lawyers who look at many elders, for example, seeking adjournments, and they would also want to do the same because they thought it's accepted practice? Can you delve into this in detail?
Sure. So, Tarun, I think that the Supreme Court has come down heavily and said that we can't have a culture of just going to court and asking for an adjournment because we want to avoid a hearing, or our client tells us, look, I don't want to go ahead with the case today, let's wait for some time. So therefore, on some pretext or the other, try and go and seek an adjournment. I think this practice now needs to be curtailed, and I think Supreme Court has taken, I think all the courts in Supreme Court are not giving adjournments just for the asking. Now, there are two ways of getting an adjournment. One is that you don't circulate a letter. On the day your case is there, you appear there, or you send a proxy counsel and say, sorry, my counsel is in some difficulty and therefore we want to get the matter adjourned. The other way is, as Senior Advocate Mr. Nair said, is you circulate a letter in advance. Now, in the first category of cases, I think now it is very consistent that all courts are taking a tough stand and saying, sorry, if you haven't circulated a letter in advance, we are not going to adjourn the case unless there's something really exceptional, which makes out a really strong ground for adjournment. So I think the door on those kind of adjournments have almost now closed. Comes the second category of adjournments, where you have to circulate a letter a couple of days in advance. Now, there also, Tarun, the other party has a choice to object to that adjournment request and send in an email saying that, sorry, I'm objecting to the adjournment. If that is done and the matter comes up in the Supreme Court, then the party who wants to object to the adjournment can say, please don't adjourn the matter. I've objected to it, and I feel that these grounds are not correct. Now, yes, this gives a judge a lot of discretion what to do. I think that with over a period of time, given that after COVID, we've had a huge docket of cases now, and there's an explosion because, there are far more number of cases today to deal with than there were before. I think that judges have started, not only in the Supreme Court, but I feel in the high courts also, started taking quite a firm position that they are not going to grant adjournment unless there is a really good reason to grant adjournment. Now, Tarun, I must tell you that this is not only about the judges and about the courts. We as members of the bar also have to show a huge amount of responsibility. I think more rules should be brought in, more amendments should be brought into various rules, whether it's the advocates on record rules, whether it is our CPC, where I think asking for an adjournment should also be said that should only be asked in exceptional circumstances. And that we should now go full force in ensuring, members of the bar, that we ourselves don't tend to ask for an adjournment just because there is client pressure to ask for an adjournment. And that kind of a thing should be curtailed. In big commercial disputes, I'm hoping that courts will soon start a practice of imposing actual costs on when adjournment is sought. So, for example, if there is a big commercial disputes and lawyers involved and are quite senior lawyers, then the costs should be extensive. Not only because that the party is paying money for his legal costs, in addition to the time of the court which is wasted. So therefore, yes, there should be a heavy cost because you wasted precious judicial time. Also because you have a responsibility that the other side has taken a counsel and had a counsel who had blocked his date to ensure that he can appear on that date, and had probably set aside other cases. For a regular hearing matter, if it is a long matter, the counsel would say, I am not going to accept any other case because I'm going to really focus and work on this case. So therefore, if the other side seeks, then he should be made to pay actual costs. Now, Tarun, I must remind you that under Order 17, Rule 1 of the CPC, there are actually rules on seeking an adjournment. I must remind you that CPC takes a very tough position. It says adjournment should not be granted as a course, as a normal course, of asking one. Second, it cannot be granted more than 3 times during the hearing of the suit. So therefore, you can't go on, the Tareek pe Tareek can't go on because the CPC doesn't allow you to do that. Third, the CPC mentions that costs will be imposed if adjournments are asked for. These costs, I think, should now, by way of practice, should be escalated. They should not be nominal costs, but should be actual costs. Lastly, the CPC also says that the court, should not, the excuse that the pleader who's pleading the case, the advocate who's going to argue, is busy in some other court, may probably entitle him a passover, but not an adjournment. CPC says that the court, this cannot be a ground that the pleader who's pleading your case is engaged in some other court. That cannot be an excuse. CPC says that under Order 17, Rule 1. CPC also says that if the advocate is not available because of his personal illness or some other ground, other than the fact that he's in some other court, which cannot be a ground at all, then also court has to be satisfied that the litigant did not have enough opportunity to engage some other advocate to come and plead his case or her case. So CPC actually sets out the contours of how to ask for an adjournment, Order 17, Rule 1, which we many times forget. I think it is time when we do complete adherence to Order 17, Rule 1, to ensure that there is no misuse of asking for adjournments. Even in the High Court, there is a system of asking for an adjournment where the other side's consent is taken, and you have to move that adjournment slip, I think, before 12 p.m., where the matter will be listed next day. There, without the consent of the other side, you can't even move an adjournment slip, if I'm not mistaken, when it comes to a High Court. Yes, in Supreme Court, you can, and the other side can object to an adjournment. But according to me, both those systems are good enough. But the issue is this. Issue is that we as members of the bar should show much more responsibility, and we should not get swayed away in asking for an adjournment just because we feel that there is pressure or there's some reason to avoid a case or to get it, rolled over. The reasons should be genuine, and members of the bar and we lawyers should take greater responsibility and ensure that we are not asking for frivolous adjournments. I think that has to be a cultural change. 2, courts, I think, have now become much more firm. Certainly, Supreme Court has. All courts are not just looking at a letter of adjournment. They are asking, please tell us what is the reason. It is not a right. It's not a fundamental right to come and circulate a letter and ask for an adjournment. We must remember that many, many people wait for months to get their case listed on a particular date of hearing before the Supreme Court, especially in leave granted cases, which are civil appeals. And therefore, the circulating of letter should only be allowed when there is genuine exceptional reason and there is adherence to Order 17, Rule 1.
Thanks for explaining this in detail. I want to raise now 2-3 questions with Senior Advocate Mr. Nair. 2 things here. Now a lot of commercial, what you can say, people who have high-stake commercial litigations have watched the program regularly, and they would like to know, in case where there is a high-stake litigation, the advocate, because of his own commitment, takes an adjournment. But the parties many times always end up questioning that my interest cost, if I have to recover money from the government, then delay, all of which is affecting my ability to pay loans. And many times dates in court take some time to come. And even a month or 2 delays crores of rupees in high-stake litigation. So where are we going wrong here? Our advocates end up taking more cases. Is a problem with the listing system so that you cannot manage which case is coming up in which court? Can you delve into this in detail so that we get a better picture?
Tarun, I think there are multiple aspects to this question. Let me just, in my opinion, give you the various aspects. Now, as my friend also mentioned, there are various ways where parties or lawyers request for adjournments. One is to make an oral request. The other is to, circulate a letter. Of course, there is an option to circulate a letter. And let me point out, and I'm saying this from personal experience, in the high courts and the tribunals, I often find opposite counsels or counsels on record refusing to give consent. In fact, even between lawyers who may be friends, and most lawyers are friends outside the court, telling each other that, look, I'm sorry, I'm constrained, but I am under instructions to not give consent for this request for adjournment that will be made the following day. And then it's left to the discretion of the court. If anybody is in difficulty, you can always make a request. You can always give that reason, because Mr. Bhandari quoted Order 17, Rule 1. The word used in Order 17, Rule 1 is sufficient cause. So if you can show a bona fide sufficient cause, then most courts would accommodate you. That's one aspect. The second is, what we've usually seen in the Supreme Court is the Honorable Supreme Court, what mostly happens between advocates on record, because most of the advocates on record regularly practice perhaps only in that court. And it's often a matter of courtesy. The thinking that I have seen is that, look, today I'm in need and I'm circulating a letter. The reason may be any. It could be that you've committed to too many cases or hearings, or somebody is traveling, or there is a function in the family, or there is an illness in the family, or something on those lines. So people generally, what lawyers do think is, or advocates on record think that, look, today I'm in need, so I'm having to circulate a letter. And if my colleague is circulating a letter, if I say no, tomorrow I could, sort of require the same courtesy in reciprocity. So it's often all about courtesy. And that's what the judges also do. When a letter is circulated, honorable judges also usually extend that courtesy. But I think this message that has gone out from the Chief Justice of India is this, that, look, eventually courtesy between colleagues will have to give way to efficiency. The kind of docket explosion, especially post-COVID, the numbers, the fresh filings, especially on miscellaneous days. This comment, it seems, was drawn after collating the number of adjournment slips on miscellaneous days, Mondays and Fridays, when fresh cases are listed or urgent cases are listed. Now, Monday and Fridays are usually for urgent cases, and it's sort of implicit in the listing that there is some urgency. And that's why those numbers were given, that a lot of these cases are listed on urgent mentionings. So please don't ask for adjournments. So I think one is the fact that all of us may be the closest of friends outside court, whether it's, law firms, filing counsels, arguing counsels, whoever is engaged to appear. We'll have to sort of, be more responsible and say that, look, this courtesy that we extend to each other, or the courtesy that the honorable judges extend to lawyers, will have to now give way to efficiency, because judicial time in times of these kind of volumes of filing is very, very valuable. That's one aspect of it. The other is, again, as expounded by my learned friend, is this, that we have to get to a system of actual costs, so that difficulty that one side faces when the opposite side wants an adjournment is sort of magnified. In international arbitrations, for instance, you can never get away with a request for adjournment unless you are ready to defray the entire costs incurred by the other side. And then this could run into hundreds and thousands of dollars or pounds, or whatever the currency is in which costs are being quantified. So that's the second aspect of it, that, actual costs. And if a party has, and in the Supreme Court, as you said, high stake commercial matters, there are sometimes multiple counsels on both sides. Today, in a bitterly contested commercial dispute, you may have 4 senior counsels, 3 junior counsels, 5 senior counsels, 2 junior counsels. You may have 6, 7 counsels on each side. So even for the purpose of calculating actual costs, even if an advocate on record or the law firm that is on record has to place the real invoices that have been raised on them for a particular hearing or appearance, then so be it. So that the other side realizes that, look, if I want an adjournment, whether it's for actual reasons or it's for tactical reasons, because often adjournments are sought for tactical reasons. You feel that the time is not right, or you feel that if the progress of a hearing is delayed, beyond a certain point, you may force an opponent to come to the negotiating table. So if there are actual costs that stare you in the face, then if there is a genuine reason and your counsels are in some difficulty, you'll make alternative arrangements. It'll come down to that. I don't think anybody will want to pay lakhs in counsel fee if there are 5-7 counsels on one side. Then it's going to come down to that. But law firms and advocates on record, counsels on record will either make alternative arrangements, or where tactical adjournments are being sought, that those tactical adjournments will stop. And I think that message has gone. And as I said in my opening remarks, there is no sugarcoating that message. In fact, if I remember, the words Tareek pe Tareek come from a very well-known Hindi movie. And the precursor, if my memory serves me right, the precursor to this was also that the character who mouthed these dialogues about Tareek pe Tareek also said that most people who come to the courts here, and in fact, majority of the people, and this perhaps holds true more in the case of individuals, come after probably selling family jewels, selling land that they've inherited, raising money for litigation. Especially in the Supreme Court, something which began, let's say a suit begins between interstate family members or neighbors or let's say a trust and its members, and it begins at the trial court level. And it's traveled through 3-4 courts, 3-4 hierarchies, and it's been on for about 15 years. A lot of money has been spent. Somebody has sold land, somebody sold family jewels. So that was what was also said before this dialogue, before this iconic Tareek pe Tareek was stated in the film. So I think actual costs, courtesy taking a backseat, and sufficient cause to be enforced in its strictest sense. In fact, let me give you an example. When I started, and it was about been 25 years plus in the profession, there was this reason called personal difficulty. Now, nobody defined what personal difficulty was. Any of us could pick up the phone, call up the opposite counsel and say that, look, we have something coming up tomorrow. I'm in some personal difficulty. And the extent of the courtesy extended in those days, perhaps there was not so much as much pressure of numbers as there is today. No, mostly people didn't even ask each other. I could have called Abhimanyu and said, we are facing each other in a bitterly contested matter on Monday, and I'm in some personal difficulty. 20 years ago, we may not have even asked each other what personal difficulty is. Today, it's actually a positive development that today that phrase personal difficulty can't be misused for taking a tactical date, because today people are asking that what is, if you are in personal difficulty, I'm sorry, I can't give consent. My client has spent money. My client has some urgency. We are pressing for some urgent interim orders, or we are pressing for some hearing. So therefore, whatever your personal difficulties, have a colleague explain to the court, so that at least the judge has the opportunity to exercise that discretion and take a call as to whether it's a genuine request or it's a tactical request. I think that's what has to be applied to commercial matters. Or in fact, let me say this, it has to be applied. You put your question in the context of commercial disputes. I think it has to be applied to every single case. It doesn't matter what the stake is. In fact, let me tell you, in this context, 5th of October 2023, I have before me an order passed by the Honorable High Court of Bombay, where a division bench has actually come down very heavily on a request that was made by the Additional Solicitor General's Office for Accommodation. And in fact, a detailed order has been passed by the division bench, where they have said that, look, repeatedly requests are made by the Office of the Solicitor General, Additional Solicitor General, and we know that it's a large office. There are other counsels, there are junior counsels who are very competent, and somebody should have been here to assist us, number one. They have also expressed their anguish and said that, often the government of the day, I don't know whether they refer to the state government or the union government of the day, often says that, look, ease of doing business, one factor is that, pendency of cases shouldn't be there. It shouldn't take time for cases to be decided. So they said, you on the one way you say this, on the one hand you say this, on the other hand, accommodation is being sought. So I think the winds are blowing in the right direction. Times are changing, and it's going to be, I think we are very soon going to be at that point, especially with this intervention that the Honorable Chief Justice has made, very directly. I think we are going to soon reach a stage where adjournments will only be granted, if at all, in very exceptional circumstances with sufficient cause being shown, as the CPC mandates in Order 17, Rule 1.
In fact, I'm going to request quick 2 crisp comments from both of my panelists. I have a 3-tier question. Tier number 1 is what the Chief Justice of India said. Tier number 2, why we speak of commercial disputes? Because any commercial disputes involve thousands of crores, or I'm talking of the big disputes. But these disputants are job generators for the country, which make the country rich. Any commercial guy will employ people to achieve a certain aim, and that employment will make poor Indians rich. Point number 1. Point number 2 here was, when India was a $400 billion economy, perhaps the quantum and the gravity of cases wouldn't be the one that we see today when it's a $3.5 trillion economy. We want to become a $10 trillion economy. Almost all the presentations that I have seen that are made to venture capitalists abroad or promoters who invest in India talk about how many days does it take to solve a dispute. So if in a 3-year time frame, if a dispute is settled and 6 months are eaten away, or say a year is eaten away by adjournments, then even that data goes to investors sitting in New York, London, Japan, and Australia, and they may or may not make a decision to invest in this country basis the enforcement of contracts and the time taken for dispute resolution. So it's in fact a very serious issue. And it could mean billions of dollars of money not coming to this country or coming to this country basis what happens in the courts. Given this background, I request 2 quick comments from both my panelists. Over to you, Advocate Abhimanyu Bhandari.
Well, I think the intervention by the Honorable Chief Justice is very welcome. I think it's a very positive sign when the Honorable Chief Justice speaks the Tareek and says that adjournments should not be asked on frivolous grounds. It sends a message to all the courts around the country, all the tribunals around the country. It also sends a message to all the lawyers around the country to behave more responsibly when we are seeking for an adjournment, and to exercise caution and restraint and not go on frivolous grounds to seek for an adjournment. So I think that's really, really welcome. Second, I think that what is good, and I've noticed because I practice in the Supreme Court and also in Delhi High Court and in the forums that we have in Delhi, various forums, I've noticed that all forums, whether it's the NCLT or the NCLT, or whether it's the Honorable Delhi High Court or the Supreme Court, I'm noticing that now courts are becoming more reluctant on granting an adjournment merely because a lawyer stands up and says that for some personal difficulty or for some reason. And I think that the shift is to ensure that adjournments are not granted on frivolous grounds. So I see that positive development as a personal practicing advocate coming up. I also see that a lot of members of the bar now feel reluctant to go and ask for an adjournment on some frivolous ground. So I do see a change in culture over the last 10 years that now I'm seeing, which is quite prominent. Third, yes, our number of disputes, complexities of dispute, and the amount of factual issues that are involved in a dispute have all grown, because as the economy has grown, matters have become more complex, requires far more time of judges to devote, lawyers to devote. But our judiciary has not grown in such a big way. Number of judges in various high courts have not grown in that number of way. Number of courts have not grown the way the economy has grown. I think, therefore, we are now living in a situation where we have far too many, very few number of commercial courts for the number of commercial disputes that are there. Commercial disputes are not only disputes of suits, civil suits, but they can be writ petitions where companies are asking for relief against the government and are knocking the door under Article 226 of the Constitution before the High Court. There could be complicated electricity matters. There could be arbitration awards, which a court has to look into in a 34 stage, whether it should uphold the award or not uphold the award. And therefore, I think that the whole system will get clogged if we now don't, as a measure of utmost urgency, show restraint in asking for adjournments. And courts should come down heavily on people litigants trying to take frivolous adjournments. And one way to do that is to impose, as Mr. Nair rightly said, actual costs and not just nominal costs.
Yeah. Thanks for that intervention. I'll go to Senior Advocate Mr. Arvind Nair for his closing comment of the day.
Tarun, as I said, and as Mr. Bhandari also said, times are already changing. Courts, as I said, are also very conscious. Our honorable courts are very conscious of the value of the judicial time, the docket explosion, the difficulties that are being faced, and of course, the fact of the commercial fact of ease of doing business is also a factor. And in fact, I must tell you, these comments that I refer to, which have been made by Honorable Division Bench of the Bombay High Court, were actually made from whatever the memo seems to indicate, that it was the case filed by an individual. So it wasn't even, so to say, a commercial dispute. An individual filed something against the government. And in this case, comments were made that, and eventually, after saying several things in a 4 or 5 page order, the Honorable High Court stood over the matter to the next day. And this is something I'm also now seeing both in the Honorable Delhi High Court and the Honorable Supreme Court, that somebody wants an accommodation on Friday. There are times when a lawyer comes up and says that, look, there is an illness in the family, or I have had to urgently travel. Sometimes those personal reasons are also genuine personal reasons. I still feel that tactical adjournments is not always something which makes somebody want to circulate a letter. Sometimes they can be genuine last-minute reasons. But now I am noticing that this entire thing, as I said, of extending courtesy to each other has given way to increasing efficiency, because if you make this request on a Friday, the Honorable Court is saying, okay, all right, please come on a Monday. If you make this request on a Monday, the judges are often saying, all right, we'll hold it over for the next day. You come tomorrow. You can't come tomorrow, you come day after. That also gives enough time to the counsel on record to make alternative arrangements. That's one aspect of the matter, which I think has now caused a lot of reluctance in lawyers to go and seek an adjournment, number one. Number two is that if you want an adjournment, you will then get the next date as per the convenience of the court's diary. And what is now happening is that the judges are saying, all right, we are in November, you want an accommodation on the 6th of November, fine. Our diary seems to indicate that the next convenient date is March 2024. Come in March 2024. So now, you can't have your cake and eat it too and say that, look, there is some urgency, but I don't want to argue this matter today. So please give me time after 2 weeks. Or let's say I have some plans. Please post it immediately after Diwali. So now what the honorable courts have started doing is they are saying, all right, judicial time is more valuable, and it of course is. So please, if our diary seems to indicate that the next convenient date is April, you come in April 24. Or if everybody is getting a date of July 24, you'll also get a date of July 24. It doesn't matter who appears, what request is made, what urgency is shown. I think these two factors have gone a long way in ensuring that, this whole practice of asking for tactical adjournments comes down. And I think with the Honorable Chief Justice of India, focusing on this is going to be completely eliminated. I think it's only a matter of time and a very short duration of time.
Thanks for that intervention. It was really interesting talking to you both. You made some very, very, very good points, a lot of insights into this issue, also from the economy point of view, also from the rule of law point of view. This series has gone pretty well. I appreciate that both of you could make time and joined us for this show. And I thank the viewers also for tuning in. Thank you so very much.
Thank you, Tarun. We always enjoy your very insightful questions. Insightful questions lead to good answers, I think.
Really appreciate the comment. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.